Welcome to today's webinar, which has been jointly organised by the National University of Singapore Centre of International Law and the Singapore branch of the International Law Association. My name is Anthony Chin-Nichols, and I'm an international arbitrator based at Forte Law here in Singapore. For the purpose of today's seminar, however, I'll be the moderator. And indeed, at the end of this session, we will have a Q&A session, whereby I will be assisting with the discussions. In the meantime, however, I think of myself more as a tour guide, in which I'll be accompanying you, the audience, on this journey as we understand the relationship between international law and technology. Now, I'm very glad to say that we have four speakers, four excellent panelists, who are going to be helping to guide us on this journey. Before we do so, however, a few housekeeping matters. Firstly, I would ask you to keep your microphones on silent, on mute at all times. If you feel like keeping your videos on, that's your choice, but please do make sure to keep your microphones on mute. Secondly, we'll have four presentations today, and at the end of them, we'll have a Q&A session. There are two ways in which you're able to ask questions during this Q&A session. The first is that you're able to ask questions through the chat function. Now, if you see at the bottom of your screens, there's a chat box. And indeed, if you feel like doing so during the course of the presentations, you can write your questions in and the panelists will be able to see them. Alternatively, during the Q&A session, you can also raise your hand like this. Or you can do it old school like me and just try wave. I'll try and hopefully I'll see you and then I'll try and answer your questions. I'll ask the panelists to answer your questions. So without any further ado, I'd like to turn to our first speaker, Mr. Dimitris Ioannidis. As a bit of background, Dimitris is one of the founding members of Roche, Ioannidis, and Megaloudis. He has a busy practice in commercial dispute resolution based in Massachusetts. However, he has also served as an expert in a series of courts in the United Kingdom, in the United States, and elsewhere. Recently, he's also in the process of writing an article on whether artificial intelligence will replace arbitrators, something which I find to be, frankly, quite terrifying as an arbitration lawyer. Nonetheless, on that note, Dimitris, over to you.
Good morning. Thank you. Thank you, Anthony. It's a pleasure to be here. It's a privilege, actually. Thank you. I thank the organization for making this possible. I have to tell you that this topic is of great interest to me. I'm passionate about legislation, innovation, technology, and how lawyers fit into these sort of discussion. As a brief, maybe a couple of points that I'd like to make before I begin my presentation is that I will refer to a lot of technologies that have been created at the Massachusetts Institute of Technology in Boston, Massachusetts. I do want to say that I'm not affiliated in any official capacity with that university. However, there are a couple of things that are very important. I judge the MIT Enterprise Forum of Central East Europe and also the chapter of MIT in Athens, Greece. And I also represent a lot of inventors and a lot of scientists from MIT. In the course of that interaction, I became interested in sort of understanding how technology is developed, how scientists do it, and some of the issues that they're facing in commercializing these ideas. And over the course of the years, I began to be fascinated by topics that actually have that are emerging technologies, but at the same time, the legislative framework behind such technologies doesn't really exist. So these are some of the topics that I'm interested in bringing forward and kind of discussing with the audience today and with you guys. And I also want to tell you some things that I've learned throughout my sort of relationship with a lot of people at MIT. Number one, the first thing that I can tell you is that MIT is the 13th or 14th largest economy in the world in terms of the companies that come out from this university. Probably it's considered to be one of the top schools in the world, but there's a lot of wealth that is being generated from that university. The second thing that is very important about that school is that they do not care about money. They care about social impact, and technologies that are usually coming out of that university have to have a significant social impact. And the third thing that I think is critical and very important to lawyers is that when you kind of look at the scientists and the mentality of the MIT world, they actually celebrate failure. And that's very interesting, especially for a lawyer like me, because I don't think I can ever celebrate failure, especially when I don't do so well on a particular case and I get the decision from a judge and I haven't been able to be successful in my presentation. Imagine if I call my client and say, listen, the judge didn't accept what the arguments have been, but let's put all that issue aside. Let's celebrate our failure because we've learned. It doesn't work like that with lawyers, but it does work in the world of this particular school, because if something fails, they know it doesn't work, and this is what they celebrate. They move on to something different. And that mentality doesn't really work in our community, in our legal sort of world. Now, the other thing that I'd like to do is I want to introduce you to some amazing technologies that are coming out that, for my purposes at least, are an indication of where the world is going to be in a few years from now. And these are technologies mostly at MIT that I have been intimately involved in the sense that I either represent the clients or that I have been sort of participating and, being involved in some minor perhaps capacity. But some of these technologies will show you what the future perhaps is going to look like. So I'm going to share my screen. I have a presentation that I can sort of go through and kind of give you some of that information. So forgive me for a second. Okay. I hope that everybody can see my screen. And the first slide that I have is a very important question for me. And the question is, what should come first, innovation or legislation? And again, this is a question that I'm very passionate about. And I'm not sure I will give you a specific answer that says innovation or legislation should come first, or whether or not the two of them should go together. But if we think about our existing world today and how innovation and legislation come about, I believe that there's a lot that needs to be sort of improved. So this is the question that I'm going to try to answer, or at least deal with, in my presentation. The first discovery that I want to mention to you about is the artificial nose. Now, Andreas Merschen is an MIT researcher. He developed this artificial nose for the US government, and I actually represent Andreas. We are in the process of commercializing the artificial nose. But what is this artificial nose all about? And why is it that I'm bringing this sort of discovery to you? Now, back in 2008 was the first time that scientists at MIT were able to kind of mass produce smell receptors. Now, we all understand that dogs have a very, very keen sense of smell, and they can detect a lot of different medical conditions. They can do a lot of different things. The artificial nose, I got to tell you, is 200 times better than a dog. And it was developed for specific purposes for the US government, but it has a lot of other uses. Now, the first artificial nose that was created appears on the lower bottom right of my presentation slide. It's a little gadget this big or whatever. Very, very sort of preliminary type of an idea that came about. However, now the artificial nose is like a little plastic kind of a thing, and we are in the process of putting it on our phones. So the future of phones will include not only a camera that takes a picture, but at the same time a smell receptor, a smell sensor that's going to detect diseases or things that are happening in our body. Why is that important? Because Andreas Merschen says that humans give a certain smell as we go through space. And that is detectable. Now, we haven't gotten to that stage yet in terms of the technology, but my question as a lawyer, and this is an article that Andreas and I are going to be working on in the near future, my question as a lawyer is, can we smell the intent of parties or the witnesses, or can we smell their mental state? Imagine what that will do in terms of litigation if we can actually have a device that can smell the mental state. or the intent of parties, especially in contract formation, in breach of contract cases, in all these types of things. The second slide that I want to show you is a little video that shows how dogs do it. And this is a company that we work with in the UK, the medical detection dogs. I'm going to play a bit of a part. For those that love dogs, it takes a long time to train a dog to actually smell certain types of diseases. But once a dog is trained, the accuracy rate is over 99.9%. So let me just play that. Okay, so I guess, you know, the idea behind the artificial nose is that eventually we will get to that stage where we will have devices that can actually smell certain things, certain senses or certain things that humans exhibit. And eventually I think we will get to a place where we can actually smell the intent and the mental state. The next project that I want to talk about is a question, another question, and I love to ask questions. In case anybody probably has heard me say this before, we can never patent a question. So I love to ask questions because it's not patentable. Anybody can use it. So the question I have is, what do chicken wings have in common with the future of aviation? And there's a story behind this. And again, this is another discovery at MIT because we are now creating better materials like never before. And the story goes something like this. A PhD student by the name of Kenneth Chung was sitting around with Andreas at MIT with a few other people, and they were having chicken wings as lunch. And while they were having chicken wings, the question came about, how are the wings of birds made out of? Because, you know, birds have this ability, the ability to fly through the air. They can maneuver so easily. They can, the wings of birds are extremely flexible and lightweight, but it gives the birds the ability to do all these maneuvers in the sky. How are the wings of birds made out? Kenneth Chung began to work on this idea, and here's what he developed. A new material that actually you can look at a couple of pictures of using polymers and the way that he was able to package the polymers together, where now we have this material patented by MIT, but at the same time licensed to Airbus, Nike, and a few other companies. So what is the future of aviation? Well, what scientists tell me is that in the future, airplanes are going to go up to 80, 90,000 feet in the air. And at that point in time, they're going to shut the engines off and use their birds, you know, their wings to fly as birds. Now, when I say that, people are kind of looking at me like I'm some kind of a science guy. But in reality, the idea of these types of materials being developed leads us to a new world of materials, the so-called morphing materials, materials that will actually change as they are subjected to certain circumstances. Now, this material, obviously, and this idea of a morphing kind of a wing is not something out of space. It's actually a reality. And I'm going to show you a little video because now Kenneth Chung has created a company that is worth billions. He now works for NASA, and NASA actually is working on this morphing wing. So this idea of the future of aviation, where planes are going to go up in the sky and use their wings to fly as birds, is not a science fiction. It's a reality. And I'm going to play a little video to show you this is a NASA video, as I said before. All right. Let me go back to my presentation.
My congratulations to the folks in Hawthorne. It was really well, very crisp. It was a little floppier and wide, just like we saw in the spin, but all the other activities as well as exposure and open.
All right. Okay. So going back to the sort of morphing type of a wing, which is being developed at NASA, we are sort of going through this phase of creating these amazing new materials in all sorts of new discoveries that are coming about. The next topic that I want to talk about is another discovery at MIT, 3D printing, and I have the title as 3D printing and feathers. Now, we all know 3D printing, but this is a new discovery where researchers actually have been able to 3D print cells onto this mesh-like structure. And what they discovered by doing that is that the location, the shape, and the functionality are connected. So by placing these kind of cells in a certain mesh-like structure and creating the environment, the cells take a certain functionality. What that means is that we are 10 years away from actually 3D printing human organs on demand. The issue with the feathers is that I've been working on a project whereby the question is, can we create 3D print natural fibers, feathers, and things of that nature? And the answer is yes. So we are actually in the process of kind of recreating a world where things are going to be very, very different in the near future. Artificial intelligence is a topic that has been discussed a lot, but I do want to talk about Stephen Thaler, who is a client of mine, the inventor of a device or a platform called Dabus. Dabus is an artificial intelligence platform that actually can create stream of consciousness. And Dabus is a device that has filed patent applications in the UK, the US, and the European Union, all of them rejected. And the idea behind Dabus was whether or not an artificial intelligence platform can own a patent. And of course, that leads us into this idea of personhood. So as lawyers, we have to think about these things. Can an artificial intelligence platform have a legal existence? And that's a topic of discussion that is coming up in a lot of different places. And, do we actually recognize that as a legal existence? And do we recognize rights to our artificial intelligence platforms? And Stephen Thaler is leading the effort in trying to get organizations, international organizations, to recognize artificial intelligence platforms as having a legal existence. The last discovery that I want to talk about is Google's AutoML. Back in 2020, March of 2020, Google came up with a paper, and the scientists said, look, we now have made a discovery whereby we are creating algorithms that are mutating and developing on their own. And that's a new discovery because an algorithm usually is created by humans with a certain bias. By allowing an algorithm to mutate and develop and kind of push away all the weaker algorithms, what we are now doing is we are creating research in a matter of days that took many, many, many years. And we are eliminating bias because the algorithm itself produces and kind of mutates and grows and develops. These are all immense discoveries that are going to change, I think, the future of our world. And if we project into 50 years from now, then the original question that I had at the beginning of my presentation has a lot of relevance. So I like to think of the future. I like to think where all these discoveries are going to lead us. And then I bring in, the topic of discussion, because I think we lawyers a lot of times miss a lot of different things. There was a conference in 1983, 1984 at MIT on artificial intelligence. And some of the views that came out back then at that point in time and a book that followed are very important. If you look at the venture capitalists and you look at the business world, they really don't care much about things that don't allow them to make a lot of money. So we have to also consider the business views. We also have to consider the scientific views. And we also have to consider the fact that a lot of lawyers do not participate in these types of conferences. So this was an extremely important conference on artificial intelligence. Lawyers were not invited. Lawyers did not participate in the forum, and they typically do not participate. Now, we do not innovate, and I don't care what people tell us, but we lawyers do not innovate well, and the statistics are incredible. We spend less than 1% on R&D in creating programs or platforms for lawyers when the world is expanding significantly in terms of innovation and R&D. Now, if you look at markets and the reports on AI that they are producing, you will find that they actually, there's a lot of money in artificial intelligence in all sorts of sectors, but nothing reported for law. Now, I love this picture, and I got to tell you, my question is, where do we fit in the superhighway, the innovation superhighway? And what I can tell you, and I love the picture because you see, you know, 3 different lanes. And I can tell you that as far as I am concerned, the scientists are on the left lane. They go very fast. The business people are on the middle lane. They go fast, but they follow the science. And the lawyers don't really exist in this superhighway. As a matter of fact, I believe we are probably on the breakdown lane with our foot firmly on the brake pedal because we're so cautious about everything. And we always look in the rear view mirror because we always care about precedent. So if we look at the rear view mirror, how can we look at the future and think about innovation? So we really have to kind of think about our approach. The business leaders, as I said before, they care about monetization and things of that nature. So innovation, basically the way we handle it is a mismanagement kind of a way, because we don't all work together. We have divergent interests, we have conflicting interests, and we don't really work together in terms of innovating. How do we handle innovation? Gary Matthiessen, he's a lawyer and he teaches a lot and talks a lot about this stuff. Basically, the way it kind of works now is that innovators create things, and you know, the companies sort of get funded. They bring these ideas to the marketplace, and then we've got some dispute, and cases end up in court. And we've got a 65, a 70-year-old judge who is looking at technology with expert testimony, cannot even use the phone. And we are actually legislating from the bench. And in a lot of cases, we are doing that because there's no other way to talk about legislation before, you know, there's a lot of social trend setting and the society kind of works things out. And eventually the legislators may end up, you know, doing something, but it's so bureaucratic, it's so delayed, where the lawyers are being asked to provide what we call soft law advice. And we use, again, precedent, we use experiences, we use existing legislation to kind of come up with things that may not fit very well when it comes to innovation. Judges talk about artificial intelligence, but I got to tell you, I'm reading some of the stuff that is being taught to judges, and I'm saying, oh my God, you know, they're so far away from technology. They're still talking about artificial intelligence in a way that it helps them handle documents and things of that nature. Well, that's the old-fashioned way, I think. And I apologize again, something happened to my screen, but back in January of 2021, I organized 2 classes for MIT on this specific topic. And I had some older lawyers kind of participate. And everybody said to me, all these lawyers were saying, no, innovation has to come first and then legislation. And I had 5 law students who came on board, and they actually said the exact opposite. They said, no, we've got to legislate as we are developing innovation because this system doesn't work. And I think that makes sense. So what I want to conclude is to kind of tell you that there's an intense growth in terms of innovation. The technological advances are incredible. They're happening around us. We do not participate as a community. We wait for things to happen and come to us. We are not part of the technological train. And the legislation aspect of it is critical if we want to be relevant. So the way I talk about innovation and legislation is lawyers have to become relevant by being engaged at the initial stages of innovation. And if we wait for things to come to us, we are going to miss that train. And I think from my point of view, both legislation and innovation have to go hand in hand. And I think that concludes my presentation. Thank you, Anthony.
Thanks very much, Dimitris. So at the beginning of your presentation, I mentioned that you're writing an article on how AI could be potentially replacing arbitrators. And during your presentation, you mentioned this technology which you hopes will smell the intent of parties. Now, I was just thinking of cross-examination and the fact that counsel's entire role is to try and sniff out the intent of parties. So essentially what you're doing is you're putting people like myself and all the arbitration lawyers out of business. Thank you. On that note, let's now move on to our second speaker. So today's second speaker is Dr. Berenice Boutin. Berenice is the senior researcher in international law at the ASA Institute in the Netherlands. Her work focuses predominantly on international responsibility, security, and new technologies. Excuse me. She's also the leader of the Dilemma Project, which stands for Designing International Law and Ethics into Military Artificial Intelligence. So with no further ado, over to you, Berenice.
Thank you so much, Anthony, and thanks very much for the invitation and to organizer for a very flawless organization. Let me share my slides. All right, this should be working fine now, yeah. All right, so I will address today a topic that is perhaps a slightly different perspective than our previous speaker, but in a sense also very much related to, and in particular, I can already say that I fully agree with Dimitrios' conclusion about how legislation should go hand in hand in innovation and lawyers should be involved from the outset. My conclusion might be similar. And perhaps to echo Dimitrios' geographical proximity with MIT, I am based in The Hague, the city of peace and justice, the host of the International Court of Justice, of the International Criminal Court. So that might also explain why my presentation is more focused on public international law, and in particular on use of technology by states as a specific actor of the international system. And I will look in particular at the technology of artificial intelligence, although some of the discussions I will present also concern other types of technologies. So first, very briefly, let's talk about what is AI, because I'm not going to spend all my presentation on that, but perhaps not everyone is that familiar with the notion. When I will talk about AI, I do not have a robot in mind. Sort of humanoid thinking robot is not, it might happen one day, but it's not the current most important developments in AI. So what we are talking about currently are these kinds of data analysis, maps, graphics, and other complicated mathematical formulations that will help do some prediction. So just briefly to define, so AI is a discipline. First of all, it's not something that exists out of the blue. It's a discipline that seeks to develop computer system that would perform tasks which traditionally only humans could perform. And of course, we see already in this definition that AI is not a static concept, because the more something becomes routinely done by computers, the less it becomes artificial intelligence. So certain things such as navigation with GPS, nowadays it's so common that people don't necessarily see of this as AI, which is quite interesting when we talk about regulating technology. If the technology itself, the definition changes all the time. And briefly, as mentioned also in the previous presentation, currently it's a lot about machine learning, which is a sort of subtype of AI, and it can really process data at a speed and scale that goes so much beyond human cognitive abilities that it really can surpass humans in to be clear, in certain specific tasks and contexts. And the problems with machine learning algorithms is that they're extremely complex, and there's difficulties once a decision is reached or is proposed by the algorithms. It's very difficult to trace back the reason for this decision. And I will give a few examples of why that, of course, can constitute serious problems from a legal point of view in terms of remedies and accountability. So let me briefly go through some examples to give a bit of concreteness also to the discussion of some examples of how states are using AI. And of course, the main example and where there's the most active debates in international law, and in particular in Geneva yearly, is AI controlled weapons that are also called autonomous weapon system. Some people would refer to them as killer robots. And to be clear, they are not actual robots. It's just integrating AI in all levels of military functions, for navigations, for recognition of images, for assessing whether something is a legitimate target, etc. And this is, of course, very active in the US, which is probably the most advanced and active country in the world on the topic of military AI. They have a specific center within the Department of Defense dedicated to it. But it's not just an American thing. So we also have in Europe, this is an article from 2 days ago, where several European countries are joining forces to build a plane, an aircraft that would not be completely unmanned or completely autonomous, but would feature a lot of AI sensors and systems into the plane. And just to show that it's not just the Western world, my Japanese is not excellent, but I assume some of you in the audience might get an idea of, might read through this text. And so also in Japan, there's discussions to do this human-machine teaming in the military context, where it's a manned pilot, a manned flight, but which relies a lot on artificial intelligence. And of course, there's a lot of backlash on this topic of military AI because, yeah, we don't want to have machines set loose to slaughter humans. There's a lot of ethical discussions, how ethical it is to delegate decisions to life and death to machines, and mostly, of course, legal discussions. But I would like to just briefly go through 2 more examples because although I work a lot with military AI, I think it's not the only topic where international law is relevant. AI is also used by government in the justice system. So we've heard previously in more commercial disputes and perhaps using AI to facilitate the tasks of judges. It has been done in the criminal justice system to predict the risks that criminals would reoffend. And these algorithms, so this back in 2016, had a lot of problems of bias. And because the decisions was based on algorithms, due to the lack of explainability, and in that case, also a bit of commercial interest because the company argued the algorithm was proprietary and it could not develop the code, the victims of this prediction did not have any remedy or redress. Of course, quite problematic. A lot of discussions currently also in facial recognitions. In Europe, we are starting to think whether we perhaps even want the police to use facial recognitions at all. It's been used in other countries. Again, a lot of backlash links to errors, lack of remedies, and human rights violations. And finally, a little example from my little country of the Netherlands. The Dutch government had used for a couple of years an algorithms to try to automatically detect welfare fraud. And well, there has been court cases, and the government was, the court in The Hague found the government violated human rights by using this automated social welfare fraud detection. And at the moment, people are getting compensation, all the people that were unlawfully, automatically put on a fraud list. All right, so now that I've been through a few examples, let me check the time because I am conscious of the time. I will wrap it in 7 minutes, Anthony. Now that we have a more concrete view of what is happening in practice, I would like to just map some of the main issues related to international law, and I would do so in a rather perhaps general way, but I really look forward to discussing further during the Q&A. And my first question relates to a question that was asked in the previous presentation as well. Do we need new laws? My core idea there is that from the point of view of public international law, there is no legal vacuum. There are a bunch of very established international obligations in terms of international human rights law, in terms of international humanitarian law, for instance. So we do not start from blank, and human rights are, of course, extremely relevant into a lot of the AI applications we discussed. And when it comes to AI in warfare, of course, humanitarian law fully applies. So we are not in a situation of legal vacuum, but we are in a situation where we need to do some interpretative effort to unravel some gray areas where, for instance, so of course, the right to privacy applies in the digital context, but how exactly can we operationalize and implement the right to privacy when it comes to algorithms used, for instance, in social media? So it's not that there is a legal vacuum, it's how do we operationalize it? And therefore, I think that perhaps there are some gaps, but rather than starting to try to make a new treaty about technology, which would be extremely difficult to achieve. If we could start by first implementing what we have, I think that would be a very good first step. Another question in this regard is, do we need a preemptive ban on certain uses of AI? There are discussions on autonomous weapon system. A lot of people, there's a very active campaign to stop killer robots, which advocates for an international treaty to ban autonomous weapon system. There's a lot of campaigning in Europe to ban facial recognition. Is it possible? Is it useful? Well, it would be extremely difficult to achieve such ban, mostly due to issues of definition. If you want to ban autonomous weapon system, you first need to define autonomous weapon system. And after 8 years or more of debates in Geneva, no states or delegations agree on a single definition of autonomous weapon system. Therefore, it would be difficult to reach a ban. But more importantly, I think it's really important to consider that the current law that is applicable in bindings already constrains the use of AI by state. Again, no legal vacuum. So when states decide to use, for instance, facial recognition or integrate AI in their armed forces, they are, or in any case, bound by their human rights obligations and other international law. And those boundaries, so let's briefly go through it. Yeah, the law applies irrespective of the complexity or the novelty. It might be difficult to interpret, but that's the job of lawyers and legal advisors. The government cannot simply say, well, I don't know how human rights can apply to my new AI technology, so I will just swipe it under the rug. It doesn't work. But what I also want to insist more precisely is, of course, when you implement AI in, for instance, your police force, you're bound to respect human rights. But I think that human rights obligations and other international norms are relevant from the outset, from the moment that you start designing and developing technologies. And that's very much, in particular, in the case of AI, from the moment that you start designing AI and you seek to design a system, that you put some system requirements, you put some, you try to integrate certain goals, functions, and values into the system. I think that fundamental rights should be part of the goals, functions, and requirements of an AI system from the outset. That is the idea of ensuring that the system is able to comply with international law. And I will push the argument so far that to say that, in my view, the current legal framework already imposes an obligation on states to seek to integrate fundamental rights at the stage of the design of AI. And I think, well, briefly, because I'm out of time, Article 36 of Additional Protocol 1 of the Geneva Convention is a specific provision, specifically in the military context, where there's an actual obligation when developing a technology to seek to ensure that it is able to comply with the Geneva Convention. So that's a very interesting provision, which seems directly relevant to AI design. But more generally, and that allows me to reach towards the end of my argument, there are some core positive international obligations in the international legal systems, main of which would be the duty to ensure respect for humanitarian law. So states not only have the negative obligations not to violate IHL, but they also have a positive obligations to try to take steps so that the state and other actors or around it are seeking also to respect IHL. The same applies to human rights. State not only has a duty to not violate human rights, it has a duty to actively make sure that entities and actors within its jurisdiction also abide by fundamental rights. And that leads us to the connection between the public international law and the more private dimension. Under Article 2, Paragraph 2 of the ICCPR, it is quite clear that states, in order to promote human rights in their country, have a duty to pass domestic regulation that ensure that other actors, for instance, big tech companies, act within the threshold of human rights with respect for human rights. So the state has an obligation to pass the legislation that will be binding on the corporation. So there again, I think there's not a total legal vacuum. And I think that the human rights framework is extremely relevant to the private world when it comes to those human rights sensitive applications of technology. To conclude, to move forward, the next steps, I will reiterate that we, I think, should really focus first on implementing the existing legal framework in the context of new technologies, that we should seek to implement this legal framework from the outset, from the stage of the development, and not just wait for the technology to be developed and then see how it aligns or not with human rights. That we can develop interpretative guidance on how the law applies rather than trying to draft new international law. And that in the end, we need to operationalize this legal framework with non-legal things, with technical tools. We need technical certification and verification mechanism to know whether a system is able or not to comply with human rights. And with this, I will just briefly share my contact details. Leave that slide on for 2 seconds. If anyone wants to reach out to me, I'm always happy to. And this concludes my presentation.
Thank you very much, Berenice. I certainly had some questions at the beginning, but before you gave this presentation. I'm glad to say that you've answered some of them. And certain other questions have actually arisen in my mind, at least, but I'll keep those till the end. On that note, let's move on to our third speaker today, which is Mr. Jean-Rémy Demestre. So Jean-Rémy is an international arbitration and public international lawyer who previously worked with Professor Alain Pellet in cases including before the ICJ. In his most recent incarnation, he is the co-founder and the CEO of Jusmundi, which is a search engine for international arbitration and public international law. So Jean-Rémy, over to you.
Okay, so thank you very much for the invitation. I'm very happy to talk after distinguished speakers. And I was quite interested by what you said, Dimitrios, about the fact that innovation and lawyers are coming, it's two different worlds. And going from a lawyer to a business leader, I could see that for sure. It's not the same way of doing. But I think it's good that it is separate. As you said, you know, lawyers are not the same role, and it's probably good that, you know, they don't try to innovate all the time, and it's probably good to switch if you want to do something different at a point. Anyway, so let me share my screen so we will not see my face anymore. Can you see my presentation?
Yes, we can.
Okay, very good, thanks. So speaking about technology and international law, I will focus mainly on what we are doing in Jusmundi, how we are using technology, because I think that's where I can bring the most value and knowledge. But I will try to broaden the speech, and feel free to ask any questions I could do it. So. First, I want to discuss one of the issues that we have identified at Jusmundi, which is about legal research and legal research internationally. The thing is that it's pretty obvious for us who are international lawyers working in international context, but it's not so easy to identify how big this problem is globally. When you are in a big law firm, you know, most of what you do is cross-border. It can be up to 70%. But even when you are in little firms, you have a lot of international activity. But it's not only about international activity. It's also about internationalization of the law itself. And even if you are working in your own legal system, more and more you have to apply international law, regional law, foreign law in your own municipal context. And you are pretty blind, you know, to have access to the law. As you can see on the right, already about 1/3 of the time of a lawyer is dedicated to legal research. So we can't increase that more. We can go to 50% in order to do legal research, you know, in another country and maybe complete what we would like to do. So we have a legal system which is more and more international, but at the same time, as lawyers, we don't really have the capacity to search internationally the legal information that we need in order to produce a legal advice which is of a good quality. So it's an issue, a practical issue for us, but I think systematically it's also an issue for the system that we are trying to build, you know, for 70 years. And I took just 2 articles of the Universal Declaration of Human Rights, which requires to build a system where there is equality before the law, when there is access to justice. And the truth is that you can't have access to justice if you don't have access to the law already. And today, and I like what you said also, Berenice, about the fact that it's not only about creating new rules, what people before us have built during 70 years in terms of international law is already amazing. And there is so much to be done with it, but the accessibility of it, the way it is enforced, the way it is viewed by the population worldwide is really far away from what you would see in a municipal legal system, where the rule of law is pretty good. So this accessibility of the law is one of the issues of the rule of law. Of course, I don't want to say that it is everything, but it is one of the issues that can be fixed. So now if we look a bit more concretely about how do we search information, and this is what I am saying is really for in an international context, because of course if you look in your own legal system, depending on the countries, you will have better solutions. But basically, internationally, we are mainly looking for digitalized book, looking in digitalized books. So we have manuals, we have articles, etc., and we look into that to find the legal information that we will need at the end of the day. And it's good, it helps us to find information, but it's not enough and it's not comprehensive. And often we have to work with public search engines. When I started to work with Alain in ICJ cases, you look primarily into ICJ case law, and so it's not so big, but it's already a lot. And the first thing that I was taught by other assistants when I started to work with Alain is, do you know Google Advanced Search? So you can look with Google into the ICJ website to try to find with full text search also some new information. So the thing is that we have this traditional way of searching through books, but the legal information, the legal data is more and more available elsewhere, because institutions, national and international, are making it available. We could use public search engines, but it's also very limited because the legal research is very specific. Without entering too much into detail, the purpose of Youthmundi is to create a direct access between legal practitioners and legal information, so we can, by ourselves, be able to find information globally. Now, because we have today a topic about technology, I thought it would be interesting to discuss a bit how. So this is the slide of how Youthmundi is working behind the scene. And first, if we start left about collection of data, the first issue that we are encountering is constituting the database, because there is no international administration which is doing this job and providing private actors like us with the information. So we have to collect this information. So we use different sources. We do partnerships with institutions themselves. So we did one with ICC, for instance, but also with the Iran-US claim tribunals in order to also publish their information. We also collect legal information which is available directly online from United Nations. PACER, if you don't know, it's a public access to legal documents in the US, but you have the same system in most of the countries. And we use also what we call a collaborative community, which allows lawyers directly to upload information into Youthmundi. So we use it mainly for commercial arbitration, and through these partnerships that we built with IBA, lawyers can upload commercial arbitration awards into Youthmundi. So this is the first step: collect information and put it together at the same place. Then comes the second step, which is enrichment of data. And this part is what we call traditionally artificial intelligence applied to the law. And you see, I said we use data mining and NLP. NLP is natural language processing, is artificial intelligence applied to text. And this is part of the process that we do on documents. So metadata extractions, for instance, in an award, it will be extracting the name of the arbitrators who decided, the name of the counsels who participated. Pseudonymization, it means removing the name of the other people who are not arbitrator, not counsels, and who should be pseudonymized under the European, at least, data protection laws. Citation extraction is understanding the legal references into documents. So, you know, when you have an award or a judgment, you have references to treaties, to laws, to case law. And this is super valuable to us as lawyers because it helps us to navigate between the documents, to know how a treaty has been interpreted or how an award has been referred to in the future. And so here we built an algorithm which understands that there is a legal citation and understand the meaning of this citation, so it can interconnect automatically documents. And tagging is basically understanding legal concept. And so you have an algorithm which is scanning the document and understanding that, okay, this is about provisional application of a treaty. And so this is enriching the text, the simple text that we have at the beginning, in order to create a digital improved version of the document. And this part, enrichment of data, is a really complicated part when we use artificial intelligence. And then we have an upgraded data set with which we can create after more easily the rest of the application. And you know, in order to create what we call smart search, so you know, something which would be more relevant and multilingual, once you have the data well structured, well enriched, etc., it's pretty easy. Okay. So I hope it helps a bit to understand the background of it. So now, why we believe, how we believe it is impacting today research and practice of international law. So the first concrete objective that we target and believe we are achieving is accessibility of the legal knowledge for all. So we adopted a very different model at Jusmundi because all the information that we are collecting is freely available online. So if you type the name of a document on Google, you will find the document on Jusmundi. You can read it, you can download it, and this is the case for every document available on Jusmundi. Because we believe that this is the objective, to make the legal knowledge available. So it should be available for all. Law is public data, it's public good, it's not a private information to be privatized. Then transparency of the international legal system. And here mainly I want to talk about arbitration because thanks to the data we can collect, we can give information, insights about arbitrators, with whom they work in the past, counsels, experts. We have a tool at Jusmundi which is called the conflict checker. So you can put the name of two arbitrators and see if they already worked together in the past. So this is bringing transparency into the system. We are going with the flow. Today, more and more institutions are being transparent while protecting confidentiality still, but being more transparent. And so we try also to push this further. And the last point, which is very important, I believe, it's the equality of arms. Because, especially in international litigation, international arbitration, it costs a lot to represent parties. And there are many reasons. Cases are super complicated, etc. But also it costs a lot to do the research. And for instance, the conflict check, it was taking days before to do it, and either your party don't have the means to pay for a real conflict check, so you will do something very quickly, and so it will create a disadvantage. And the fact that we are able to drastically lower the cost of this task with Jusmundi, it's helping to give the same possibilities to different parties who maybe have not the same means when they go to arbitration and litigation. So I think it's also, allowing an equality of arms for parties. So that's what we believe, the impact we believe we have today, and what technologies like NLP for legal research are having today. Now, what we believe or hope this could have as an impact in the future. So Yeah. So, you know, there is a question of legitimacy of the international legal system, which is under construction for now 70 years. It's maybe not the best period to believe in the construction of the international rule of law. But if we look long term, I strongly believe that, you know, we will at the end of the day succeed in building an international legal system that will be more powerful, that will be more legitimate, and accepted by all. And I believe in the future, you know, the international legal system will be as accepted as constitutional law is in a lot of countries today. And I believe that to do that, we have to talk about international law, not to the only international lawyers, but to all other lawyers and to the rest of the population. So there is part of what we want to achieve is to promote international law, what it is, what it offers to the international society, in order to enhance its legitimacy at the end of the day. Now, a second very important achievement that we could reach will be to empower national lawyers. And Berenice, you also touched this point, and I think this is very important. You know, international law without the national legal system, it doesn't work really well. You know, most of the rules that we are deciding at an international level have to be applied in a national context. And if we just think of environmental law, which is, you know, very important for most of the countries today, if we don't really empower municipal lawyers and judges to apply and interpret the rules, it will never work completely. So there is also a challenge to empower lawyers and judges, which is what we want to achieve at Jusmundi. And one of the barriers is, of course, also the language barrier. So it's important to be able to do that. And ultimately, we believe that, you know, improving effectiveness of international law will strengthen the international rule of law, because everyone will use it more, will apply it more, and also probably sharing knowledge. You know, if you take like the Paris Agreement, I know, you know, recently a landmark cases happened in London about should we apply the Paris Agreement to the Heathrow case. Maybe there are like 60 countries all over the world that have, you know, tried to apply the same article of the Paris Agreement. I mean, judges in these countries. I don't see any reason why a UK lawyer should not use a Brazilian case law saying like, okay, I've decided to apply this article of the Paris Agreement and we will apply it this way. It doesn't mean that the UK judge has to apply it or to do the same, but it's relevant legal information for your interpretation and for convincing your judge. So we believe that, you know, it needs to, all of that needs to be interconnected in order to also improve effectiveness for the system. So that's the impact we believe actually at least this technology, natural language processing can have on legal research and legal practice. I try to be as short as I can. I hope, yeah, I will be happy to answer any question. I also give you my my contact details if you want to be in touch. And I will try to make this camera work again after the presentation.
Thank you very much, Jean-Remy. Actually, something you mentioned at the beginning of your presentation about the unequal access to international law resources, it's something which really strikes with me. And just before we move on to our fourth speaker, I mean, a few months ago, I was helping a university in Cambodia with the Vismoot, and I asked them to do certain international law arbitration research, and they just didn't have access to Kluwer, Westlaw, Lexis, Hein Online, etc., compared to some other students from other countries and other institutions. And I think that even at a very, very early level like that, it highlights this inequality of arms that I guess is perpetuated throughout their legal careers. But let's move on to our fourth speaker, which is Ms. Harpreet Kaur Dhillon. Now, Harpreet is a senior legal counsel and the lead counsel for APAC in Twitter's safety, content, and law enforcement team. Prior to her current role, she was a lawyer with White & Case in Washington, D.C., and she was also at the Center of International Law here in Singapore. Prior to that, Harpreet and I actually worked together in Druid Napier, so I've known her for a long time, and she's a very good friend of mine. So on that note, Harpreet, over to you.
Thanks, Anthony. Can you hear me all right?
Yes, absolutely.
Perfect. Thank you. Thank you to the organizers as well. It's a pleasure to participate in the seminar. It's a hard act to follow the other speakers. Per the kind introduction, I work at Twitter as their legal counsel, advising on social media regulation and enforcement in APAC. Anthony, you'll be happy to know that I think I'll be under 15 minutes, starting now. What I'll delve into is certainly informed by my position with Twitter, but I am compelled to stress, especially in a forum like this, that the views are very much my own. So starting with the fundamentals, and briefly, as many of you know, in the wake of the end of the Second World War, there was a great drive to create the foundational blocks of a human rights world order so that never again. In fact, one of the preambular paragraphs of the Universal Declaration of Human Rights, an instrument we no doubt know well, it states that whereas disregard and contempt for human rights have resulted in barbarous acts, the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people. So Article 19 of the UDHR expresses a principle that I am sure we're familiar with, that everyone has the right to freedom of opinion and of expression, that this right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. Now, I don't know how many of us take the time to look at this, but if you think about it, a pretty bold statement. And the treatment of a right to access and to impart information, and that regardless of frontiers. And why do you think that was important? So a seemingly simple principle, but keep an eye on a couple of things here as we move forward, that opinion and speech seem to interconnect, and this idea of a right to information. And recall, this is the 1940s. 20 years later, in the ICCPR, an instrument we know well as well, the expression of this evolves. Article 19 of the ICCPR breaks up the right to hold an opinion from the right of freedom of expression into two separate limbs. The right to an opinion is said to be absolute, according to commentators, including the ICCPR rapporteur. Mental autonomy ought not be interfered with as much as possible. For freedom of expression, Article 19 reiterates that it includes, in particular, the right to seek and impart information through any media, again, and regardless of frontiers. It also very importantly starts to expressly identify the limitation on the rights to expression and information. They are not absolute, stating that the exercise of these rights carry duties and responsibilities. And so they are subject to restrictions, and you see that on the slide. So things have gotten a bit more complicated by this time now in the 1960s and 70s. Right to freedom of expression, right to information connected to it, limitations to these rights. Now, thereafter, the next 2 decades sowed the seeds for amazing innovation, as we know. The growth of mass media and telecommunication in such a way that territorial borders are broken down. They simply don't limit the volume and pace of exchange as before. The internet is on the rise in the 1990s. The wonder of the internet, albeit by dial-up modem, as I recall. But in that context, what do you think the main concerns were for freedom of expression and the right to information? That the state will enable instead of constrain, that no one is left behind in terms of the fullest access and benefit. To illustrate, in a 2000 report, the ICCPR rapporteur focuses on 2 issues. First, that the right to information is recognized as a right in and of itself, not merely a corollary to freedom of expression. That we need that for a free and democratic society to develop. The rapporteur, in fleshing this out, focuses on access to and flow of information from state bodies about how state power is exercised. In other words, knowing what your government is doing and being able to engage with that. The second issue is to warn against excessive constraint on the use of these new technologies by the government in terms of regulation. The rapporteur suggests, in fact, that this denies the fundamental wisdom of individuals and societies and ignores the capacity and resilience of citizens to take self-correcting measures. So keep that notion in mind, the capacity and resilience of citizens to take self-correcting measures, because we know that that is being sorely tested in the present day. And then, and finally, and this is where we will stay for the rest of the presentation, as we know, in the last 2 decades, really in the last few years, our engagement with and reliance on the internet, especially social media and e-commerce and other technologies, have become all-consuming. And as far as the rights of free expression and information goes, we start to realize that this new reality is a double-edged sword. So much of who we are and so much information is now online. Government communicates with us online. How often now do we see a news report that quotes a minister's or politician's Facebook post? Our health information is communicated online. Election information is online. What was letters, phone calls, door-to-door newspapers, now a lot of it's done with just a click. And a good illustration of what that double-edged reality means is in fact in a 2018 report of the ICCPR Rapporteur. So recall the 2000 report I referred to earlier was about government overreach potentially. The 2018 report, its main thematic concern is the control that is exercisable by private companies over what we express in our data and the impact of government regulation on those companies, all while recognizing, importantly, that the right to information means the right to access and use the internet is a human right. In other words, a human right to the internet. So then that begs the question, what does the right to free expression and information, especially in today's world, mean and our right to the internet? I've picked two sub-questions to explore this a little bit further. First, does the right to information mean the right to all kinds of information, or can it theoretically, ideally be satisfied by access to certain types of information or a certain quality of information? Now, recall the earlier comment about people being able to self-correct. Now, if we apply that thinking, it would suggest all the varying types of information and we discern. But that was admittedly 2000, and in 2021, does that reasoning hold? Especially when we're contending with digital technology, which has enabled the proliferation of all types of information, as we've heard before in this session today. So perhaps it's more realistic and right-serving of the right to information to say it's a certain quality of information. But then the question is, how will that work when the right to free expression also extends to ideas? Recalling as well ICCPR Article 19, its reference to your freedom of opinion and the suggestion that that is absolute. Ideas are not immutable. They need to have room to be challenged and to grow. And that is part of how we exercise and develop our mental autonomy, let alone the innovation that can result in. So then where do we draw the line? What is the threshold for a good idea? Or better yet, the red line for a false or dangerous idea? And can this be left to predominantly regulatory-driven standards, which can vary quite naturally across different countries? Or if we look at this issue via a different angle, is the ideal of access to information in this digital world and what that means for your development, my development, better served by making available to us information we are more interested to see based on our interests, our likes, our purchases, rather than the full array of information? Is there benefit in that in the present context? One argument is that in a world with an overwhelming amount of information, some filtering may be advantageous. Another view is that we are handicapped by not being able to routinely access plural and diverse viewpoints. There's undoubtedly merit in that as well. I'd suggest it's about retaining some control and awareness of what filtering is occurring and why. And to effect that, naturally, transparency is an important value here. The second and last question, the turning away from the right to information. By what process is the call made where freedom of expression stops and the duty or responsibility, recalling the limitations under international human rights law, start? So recall the limitations are what is provided by law, necessary for interests such as public order, morality, the rights and reputation of others. So is it my government that knows best, or your government if you're from another country? But think again of the way the right of free expression was articulated in the UDHR, the ICCPR, that we have this right regardless of frontiers. Arguably, it's intended to be unbound by notion of territory or what this may mean for sovereign regulatory power. So then is it an international body? Is it a technology company because they're operating across so many countries? If it's a combination, what is the sweet spot in terms of the mix of international, domestic regulatory, and private power? Commentators suggest that human rights standards hold the answer, that if implemented transparently and consistently with meaningful user and civil society input, the standards, human rights standards, provide a framework for holding both states and companies accountable to users across national borders. So to quote Berenice, no legal vacuum here as well. Okay, but how? How does that work practically? The UN business and human rights principles have been around for a while, and they're important. Part of the thinking behind that was similar. Common standards serves human rights, and thus you and me. In fact, in this space, technology companies are urged to implement these principles in order to, amongst other things, stand on firmer ground when they seek to hold states accountable to the same consistent standards. But that idea is vulnerable. It lacks systematized enforceability and accountability. State standards of upholding human rights in this space, they do run the gamut quite naturally, just like any other set of standards. A company's commitment to human rights and appeal to international standards sometimes does little to sway a government who has decided their local law framework is sufficient. And it can, in the very worst case scenario, mean a race to the bottom in standards. So all the various actors, government, companies, the public, lose out in that event. Companies are equally not immune to this idea, or this issue rather, of employing varying standards amongst them when it comes to regulation. So what does that call for? In my personal view, it calls for a push for convergence with strength in numbers and systematized enforceability, a customary international law for the internet in a manner of speaking. Now, commentators have alluded to it. The 2018 ICCPR report notes that there's been some convergence among several companies in their content rules, for instance. I'd also note it requires working with government as an important, necessary stakeholder. The present ICCPR rapporteur also suggests that this gives rise to the possibility of intercompany cooperation to provide remedies through a social media council, an ombudsman program, third-party adjudication, something external. A social media council, much like the press councils that operate worldwide, which try to enforce minimum levels of consistency, transparency, accountability, it's one model. They are multi-stakeholder, they have the expertise needed. There is a matter of scalability when it comes to digital technologies and social media in particular, because think of the sheer volume of digital content. On the other hand, there is the benefit of some independence from corporate interests. And again, by multi-stakeholder, this requires government buy-in and participation. So in closing, my thesis, I suppose, is that we, individuals, each human, stands to lose out when we have governments and companies and civic groups all operating in relative silos when it comes to how we implement international human rights standards to information on the internet. It's important for the main corporate players to come together on common principles and standards, and there is some progress in that in certain content areas, and to collaborate with governments and vice versa in doing so, in order to serve the public sustainably and responsibly in this space. Also, because it will be an important and arguably necessary counterweight to domestic regulatory powers that can realistically be exercised in very different ways depending on the system or country. Technology companies can take the lead of this or work more practically with lead governments in doing so, and there are some leading in this space at the moment, and it will mean being open to a process that targets common standards, external transparency, and accountability. So with that, I'm done. Thank you very much for listening, and I look forward to some of the questions that might come up.
Thank you once again, Harpreet. A very, very smooth and very comprehensive presentation. So we've now entered the part of the webinar whereby we want to open up the floor to questions from the audience. And as I said at the beginning, there are really two ways to do this, but by this stage, I guess the main way is just to physically raise your hand or use this fantastic emoji we have here. So on that note, before I open the floor to the questions to the floor, I actually have one or two questions that I myself want to ask. And if you don't mind, I'll take the liberty of even abusing my position as moderator and asking those questions first. So my first question is to Berenice, which is, you mentioned during your presentation that there's no vacuum currently of legal provisions which stop or which limit the use of artificial intelligence. And I think you referred to the additional protocol as well as the Geneva Conventions in that respect. But how close are we to having something more concrete and more specific which limits the use of artificial intelligence for military purposes? And I think in the context of this question, what I have in mind is that there seem to already be instances in which artificial intelligence is already used for military purposes, perhaps in a defensive capability. If we look at Israel right now with their Iron Dome technology, or even state-sponsored computer viruses, to some extent, these are already militarized uses of AI. So to what extent are there discussions about further limitations?
All right, I'm happy to develop that aspect a little bit more. So there is a lot of debate, and a lot of people think that the current law is not enough and we need at least a little bit more regulation. I will still start by saying there's a lot in the current framework of the Geneva Convention. So for instance, and that's going to be a bit lawyery, but for instance, any weapon that is inherently unable to act within the principles of proportionality and distinction is unlawful by definition if it's inherently unable. That's very rare because most weapons are not inherently unlawful. But in many circumstances, then the lawfulness depends on, it's not the weapon itself that is lawful or not, it's how you use it. So, or the AI system. And that's why the ideas of bans are not very productive. It's how you use a given AI system. Do you use it in line with the principle of proportionality, distinction, military necessity, balancing with civilian lives, etc. So those rules apply, and these are, I think, rather concrete. And that's in that sense, trying to regulate the technology as a whole, when what matters is much more how do you use the technology in a specific context, and if at specific context, number of rules will apply. I won't go into politically sensitive discussions on the Iron Dome. Law applies there as well. It's an extremely complex legal construction because of the territory and stuff, so we won't go into controversial things, but in general, also in defensive applications, rules such as limits to the right of self-defense and the necessity that self-defense should always be proportionate also apply. So for me, these are relatively concrete, right?
Fair enough, fair enough. Again, I have more questions which I would ask you, but maybe I don't want to monopolize the time. So
maybe, Anthony, I can ask one question to Harpreet about what you discuss, because I'm very interested in freedom of speech and how to find the right balance. And I can't imagine how it is complicated for a company like Twitter to do it when you have to decide, like you did it also in the US the past months. And I was wondering what is the governance inside the company in order to take this kind of decisions, when you have to decide that, okay, we can't tolerate anymore this kind of messages because it is not freedom of speech, but it is something else. Who is in charge of that? Do you have a kind of committee? Do you consult with external people? Do you know how it works?
Yes, I am quite well acquainted with the framework in the company. I mean, I will speak about Twitter, but also more generally my understanding of how other social media companies do it, because there is some generalities, which is that there is a pretty defined workflow or an escalation workflow within the company. So it tends to go up pretty high to people who are specialized. It could be, depending on the subject matter, specialized in that area of content law, their area of international law. A lot of international human rights law does come into this. And then there is also external stakeholders. So we don't do it in isolation. No one, I think, does it in isolation just within the company. There will be referring it to external experts and external stakeholders for them to weigh in as well in how we take the decision. And that goes not just in taking the decision, we've implemented it, let's reflect on it. What does this mean as a precedent? That whole kind of that circle keeps moving constantly in the social media space.
Fantastic.
Thanks.
Can I take this opportunity to open it up to the floor? Does anybody have any questions? And I think that we're rapidly running out of time. So if you do, please feel free just to turn on your camera and just introduce yourself and ask the panelists questions.
Hi, sorry, I'm sorry I may not be able to turn on the video right now, but if I could just quickly ask a question. I'm Batul. I'm a lecturer in the Maldives National University. So actually my question is to Ms. Boughton, Dr. Boughton. Actually, maybe the same question like Mr. Anthony has said earlier. But what I think is like, as international law is developing very slow while technology is developing very faster. So do you still think that we do not need a specific, international instrument that addresses the technology, be it in relation to warfare or other things? Because right now our approach will also be fragmented, be it humanitarian law or international criminal law or, general human rights law. So since it's already fragmented and then it creates loopholes, so shouldn't we better have a, specific instrument? Yeah, thank you.
Thank you very much. Yeah, I actually agree that the risk of fragmentation is quite high, and that's something to avoid. And I actually agree that some kind of new instrument could be useful, and that's what I hinted at with this idea of interpretative guidance, and also what was mentioned by Harpreet, the UNGP. That kind of instruments, see, are a bit in between because they do not seek to establish new kinds of fundamental norms. The UNGP is heavily based on existing human rights. So we're not here. That's what I mean by there's no legal vacuum. There's a lot of fundamental principles that are here. There might be gaps into how we apply those high-level principles to some concrete things. I totally agree that discussing AI in the military completely separately from AI in other public sector application is not very useful because a lot of the issues are common. So if there was a forum to develop such document, perhaps in the European Union, that would be based on existing high-level norms, such as, the right to life, proportionality, and distinction, and then translate them more concretely in what it means for technology, I think that could be useful, yeah. I see them something in the chat.
Thank you.
And if I may pose that a similar question to Dimitris, actually, because you started off today's session discussing regulation and international law, but how is that? How would that work in principle? I mean, in reality, right? For example, as Berenice was saying, you have this fragmentation across different areas, and in the context of new technology, you're always trying to anticipate the next step of what happens, of what's going to develop. So how are lawmakers realistically supposed to take that advanced step of regulating for the future?
Thank you. I'm going to begin by sort of asking the same question I ask when I lecture in law schools. So the question I usually ask law students is, do you know where the engineering school of your school is? And the answer is typically no. And then I ask, well, have you ever been to the engineering school? And the answer is no. Do you know what they're working on at the engineering school? And the answer is no. So there's absolutely no connectivity between the buildings, even though they're located right next to each other. If we take that next step to the professional level that we are operating, in fact, we really don't work well with scientists. I mean, we don't deal with them on an everyday basis unless we have a case that we're working on. So basically, both our educational models and our practice models are segregated. We don't have a truly interdisciplinary approach to dealing with these things. So I'm an advocate of an interdisciplinary approach to a lot of different things, which starts from education. So with respect to some of the points that the other speakers made, I agree that there's no vacuum in certain areas, but there's a huge vacuum in a lot of areas. With respect to artificial intelligence, this topic has been discussed since the 1950s. This is not something new. If you go and watch the movie 2001 Space Odyssey, which was made in 1968, it was all about artificial intelligence. And, this was in 1968. So we still are not quite sure what the legislation should be with respect to artificial intelligence. The European Union is coming out with proposals. The US is far behind. China is dealing with it, but it's so segregated that we are not building a general kind of a principle because we don't work together. We don't get together. Lawyers are usually left out of the, sessions. So I think my proposal is that the way we implement these types of things that you're suggesting, Anthony, is by creating a truly interdisciplinary approach to dealing with these issues. Because when I talk to scientists, they usually say, well, you guys don't understand this, and we don't understand lawyers. And I find that hard to believe, but there's a huge disconnect. And never mind the business leaders, and Jean Remy is going to agree with me. I mean, they don't care about anything other than making money. So the disconnection is immense. So the question is, how do we bring the parties together and talk about these principles?
Maybe if I can jump on it and give a more complete answer to what I wanted to say. Yeah, I think you're right. And, you know, like 50% of the time we spent at Tuxmundi is doing that, because half of the people in the team are lawyers by training, and we teach them the tech, how to think about product, developing it, and talking with tech people. And the other way, the other part of the company is composed of tech people to whom we have to explain international law, you know, treaties, case law, how case is structured, etc. And some of the tech people at Tuxmundi are now very good lawyers. You know, they can explain to you how an award is structured, and we create these bridges. And what I wanted to say is that, okay, like if you want to be a lawyer and you need to have a specific mindset, if you want to be an engineer, you need a specific mindset. But it's true that in the middle, you need, if you have both, you can create something new, you can participate in this kind of project. And I totally agree with that we need this kind of trainings. And there are a few now in Paris. It's very recent, 3 years, 4 years maybe, where they teach law and some basics of engineering, which I believe it's quite interesting. We'll see what will come out of it, and yeah, but it's probably a good way to move forward.
What one? Sorry, Demetrius, please.
One additional point, and I kind of like Berenice's sort of approach to this sort of, you know, no vacuum idea. I got to tell you, when it comes to space, however, there's a huge vacuum in terms of exploration of other planets. Now, if you look at the disclaimers that SpaceX program has, you will realize that on the bottom of it, there's a disclaimer that says no laws of Earth will govern interstellar activity. So there's a huge vacuum in that approach, at least with space law.
Yeah, that's definitely one of my intended next topic of research, weaponization of space.
Let's have one final question, then we'll have to wrap things up. And Harpreet, I believe this one is very much aimed at you. Has the absence of an international regime resulted in a regulatory vacuum that gives corporations owning the social media platforms too much power to control the agenda of global discourse? Any thoughts?
I mean, I'd second that notion that there actually is an international regime, there is some framework, but I take the point that it hasn't been brought down granularly to how social media works and how content regulations work. I won't and can't talk about the case of Trump specifically, but I will say that, look, the right to free expression, it comes, as I said, with responsibilities as well, and that's the same with leaders as with anyone else. Even as all companies emphasize the need for the public to be able to hear from politicians, and we recognize that social media is one important way they do it in this day and age. But as I said, no one can do this alone. That applies to companies as well when it comes to regulation and when it comes to the actions taken under international human rights standards. That applies to companies, but it equally applies to governments as well. And so we see the actions of the company in the space, it's very understandable, but the action of governments as well in the space can be equally powerful, if not more so. And so I'd return to the view that I expressed towards the end of the presentation, that this is really about a question of bringing together the convergence of some of the standards that are being applied by companies with the participation and leadership of governments as well, in ensuring that there's consistency, accountability, and transparency.
Thank you very much, Harpreet. And on that note, I'm afraid that we're going to have to end today's session. So I just wanted to say thank you very much to all 4 of the panelists and to all of the audience members who have tuned in today. Before you go, however, one or two quick points. After the seminar, the NUS CIL is going to send out an evaluation form to the members, to the audience members. And we'd be really grateful if you could fill these in and give us your feedback on what you liked, what you didn't like, what we can do better next time. If you think I should start a YouTube channel, for example, who knows, put it in and we'll see what happens. Also, please do stay tuned for future ILA events. With obviously with the pandemic globally, there's not so many opportunities for us to meet up in person and discuss. But the ILA is planning on having a series of interesting seminars, and we hope to hear from you guys about what you want to hear as well. So on that note, thank you very much, everybody, and we'll see you next time. Bye-bye.